Was the Constitution a mirrored checks agreement or an executive branch Bill of Rights? When the framers negotiated to ratify the Constitution, their worry was not that there weren't enough rights for the executive branch. Their worry was that there weren't enough checks for the executive branch. So rather than coming up with an executive branch Bill of Rights, they came up with basically a mirrored checks agreement. They disagreed about what checks were necessary, such as did rights need to be enumerated or was political surveillance adequate? But they agreed that some check, whether in courts or votes or the legislature, is required to mirror every power and impulse of the executive branch, from jury trials to impeachment or in some specialized institution or petitioner. An executive branch Bill of Rights would have said things like, 1, the president can fire anyone who petitions a court in public interest. 2, courts can grant no new remedies that were not traditionally accorded by courts of equity. 3, prosecutors have absolute immunity against civil suits. 4, Congress and the courts can empower no new decision makers to monitor local actions of the executive branch. Nobody demanded that Bill of Rights for the executive branch, but the opposite. What they actually demanded and intended to design was a portfolio of checks mirroring executive power in all times and places. As necessary to confine the executive branch to laws consented to by the people, this was before the Industrial Revolution, and the framers were not familiar with the information problems solved by the price system and distributed decision-making, problems that collective political surveillance could not solve, but only rights of individual decision-makers could solve, with the public benefit conveyed to them as rules. But the framers still understood and agreed that expansion of new functions of the executive branch without a corresponding creation of local checks as surveillance holding the operation of those functions within the law would violate what they consented to and would be unconstitutional.